Starting today, a signature mistake on your USCIS form could cost you your entire case, your filing fee, and months, sometimes years of your life, with absolutely no chance to fix it after the fact. This is not an exaggeration, and it's not a distant possibility. It is the new reality as of today. Welcome back to US Visa News Hub. I am Mr. Burhan, and this is one of the most important compliance updates of the year for literally anyone who files paperwork with USCIS, individuals, families, employers, and immigration practitioners alike. This video is for informational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your situation. Let's start with the background, because understanding how we got here really helps explain why this change matters so much. On May 11, 2026, the Department of Homeland Security published an interim final rule titled Signatures on Immigration Benefit Requests. That rule officially takes effect today, July 10, 2026, and it applies to any immigration benefit request, any petition, application, or form submitted to USCIS on or after this date. This isn't the first time USCIS has issued guidance on signatures. In fact, the agency has cycled through at least 4 different iterations of signature policy over the past 16 years, going back to a 2010 memo, then a 2018 policy memorandum that first introduced the idea that USCIS could deny, rather than simply reject, a filing with a deficient signature discovered after acceptance. But until today, that authority lived only in internal policy guidance, not in the actual regulations. What this new rule does is take that policy and formally write it into federal regulation, specifically amending 8 CFR 103.2A.7.2a, which gives it much more legal weight and removes any ambiguity about whether USCIS officers actually have this authority. To really understand why this matters, you need to understand the difference between 2 outcomes that sound similar on the surface, but are worlds apart in practice. A rejection versus a denial. A rejection means USCIS catches a problem with your filing right at intake, before real processing has even begun, and sends the entire package back to you. Your filing fee is refunded in full. You fix whatever the issue was and resubmit. It's frustrating, it costs you time, but it's survivable because you haven't permanently lost your place in line or your eligibility. A denial is an entirely different animal. A denial means USCIS treats your case as fully adjudicated, as a decided case, decided against you. Your filing fee is gone, not refunded. And depending on the type of case you filed, you may have also lost work authorization eligibility that was tied to that filing, a priority date you had been waiting years to reach, or a hard statutory or regulatory deadline that simply cannot be recreated once it's passed. Here's what makes this especially dangerous under the old system, and why DHS says it decided to act. Before this rule, if USCIS accepted your filing at intake and only discovered a signature problem later, sometimes months into processing, sometimes not until a year or more had gone by, the agency's actual response to that situation was inconsistent from officer to officer and from case to case. Some officers rejected the filing and refunded the fee. Others denied it outright and kept the money. Officers themselves, according to DHS's own explanation in the rule, were not always clear on the scope of their authority when they encountered an invalid signature partway through adjudication. This new rule removes that inconsistency entirely by giving USCIS adjudicators explicit, codified regulatory authority to deny, not just reject, any filing where an invalid signature is discovered after acceptance, and to retain your filing fee when they choose that path. And here is the part that should really get your full attention. because it's the piece that turns this from an inconvenience into something genuinely high stakes. There is no cure mechanism whatsoever. That means if USCIS finds a signature problem on your case at any point during adjudication, they are not required to give you a heads up or a chance to fix it and keep your existing filing alive. Officers may issue a request for evidence or a notice of intent to deny, but only to confirm who actually held legal authority to sign on behalf of a company, an organization, or an individual petitioner. They are not permitted to use that process to simply invite you to submit a corrected signature so your original filing can continue moving forward. USCIS's own stated reasoning here, straight from the rule itself, is that allowing a cure would unfairly let deficient, improperly signed filings hold onto valuable cap slots and priority dates ahead of people who took the time to sign their forms correctly the first time around. If your case gets denied under this rule, your only two options are to appeal that decision using Form I-290B or to start completely over by filing an entirely new petition with an entirely new filing fee attached. So naturally, the question everyone should be asking right now is, what actually counts as a valid signature under this rule? Let's break it down clearly, because the good news here is that the underlying standard for a valid signature hasn't actually changed. What's changed is the consequence of getting it wrong. A valid signature is a handwritten, wet ink signature from the applicant, petitioner, or authorized signatory, meaning the actual person who holds legal authority to sign that specific form. A handwritten X or a similar mark is acceptable if the signer is physically unable to write. An abbreviated signature is fine as long as it's genuinely that person's customary way of signing their name. Scanned copies, photocopies, or faxed copies of a form are still perfectly acceptable to submit as long as the underlying original document was properly signed by hand, in ink, before it was scanned or copied. Now here's what is not acceptable, and this is where a lot of people unknowingly get into trouble. Typing your name into a signature field is not a valid signature. Using a digital signature program on a paper-based form outside of USCIS's specific official online e-filing system is not valid. And probably the most common mistake practitioners see, pasting a scanned image of your signature from one document onto a completely different form, is explicitly not acceptable either, even if it's genuinely your real signature that you're reusing. Each individual form requires its own separately, individually obtained original signature, even if you've signed that exact type of form dozens of times before for other purposes. One more detail that trips people up. Your immigration attorney is not permitted to sign the petitioner's certification block on your behalf, no matter how much authority you feel like you've given them in other respects. The petitioner has to physically sign that section themselves. The attorney's signature only belongs on the separate form G28, the Notice of Representation. There is one narrow, specific exception carved into this rule that's worth knowing. Form N600, the application for Certificate of Citizenship, along with Form N600K, are both exempt from this new denial authority. For those two particular citizenship certificate forms specifically, if the only deficiency in the filing is an invalid signature, USCIS is limited to rejecting the filing rather than denying it. This carve-out exists because of how serious and difficult to unwind a wrongful denial of an actual citizenship certificate would be for the person involved. The consequences are considered severe enough that DHS chose to preserve the softer rejection pathway there. Now, an important and very practical point, if you already have a case sitting in USCIS's system right now. This rule only applies going forward to benefit requests submitted on or after today, July 10th, 2026. If your case was filed before today, it continues to be adjudicated under the prior framework, which again already included some denial authority through that 2018 policy memo, but without this rule's added regulatory teeth and clarity. So this isn't retroactive, but it does apply to literally everything filed starting today, which means the window to adjust your habits and your organization's internal procedures is basically right now. So, practically speaking, what should everyone filing with USCIS from today onward actually be doing differently? First and most simply, always sign your forms by hand, in ink, on a printed physical copy, and only then scan it if you need to submit it electronically. Never type your name directly into a digital signature field on a paper-style USCIS form. Never reuse or paste a scanned signature image from one document onto a different one, even if it feels like a harmless shortcut. If you are an employer, an HR department, or an organization that files a high volume of petitions on behalf of employees, this is genuinely a good moment to sit down and review your internal signing procedures from top to bottom. Make sure the person with actual legal signing authority is the one physically signing each document. Make sure signature stamps or auto-applied digital signatures aren't quietly being used somewhere in your intake process without anyone realizing the risk. And make sure your staff, especially anyone handling immigration paperwork day to day, genuinely understands that this rule now has real, enforceable teeth behind it. One last thing worth sitting with. Given how long USCIS processing timelines can stretch, sometimes many months, sometimes well over a year, a signature problem buried in a form you file today might not actually surface until much later in the process. And by the time it does surface, under this new rule, correcting it may simply no longer be possible through the old, relatively painless refile and move on approach that people used to rely on. The bottom line here is straightforward. What used to be a fixable, forgivable, relatively low-stakes mistake is not that anymore, starting today. Spending a few extra minutes carefully double-checking a signature before you submit anything to USCIS could genuinely save you thousands of dollars in lost filing fees and months or even years of avoidable delay. If this was helpful, please share it with anyone you know who is about to file something with USCIS, whether it's a family member, a friend, or a colleague at work. And subscribe to US Visa News Hub so you don't miss important compliance updates like this one going forward. Thank you so much for watching. This video is for informational and educational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your situation.